distinction be able to
Yeah.
Are we?
You're right. I think he would have done a better job for himself. They're drawing some lines. One of my colleagues talked to Strata,
I like that distinction you draw.
and his view of the thing is kind of stoic. He says, "Well, you know, I got a real good job now, make a lot of money, I'm pretty happy with things. You know,
No big deal.
if they want me to be a judge, fine. They don't want me to be a judge, okay."
Only way you can make it fair use is to slavishly.
Kind of his thing is your loss,
So
you know.
far, you've got all those other abilities. And what's interesting is you did sound much.
I think everything in Washington
Are we up and running?
on every level. The American people are just getting so fed up.
If I can ask you to subside for a moment, it's only for the sake of letting you emerge again. This is the question and answer period, and we will run until about 12:30. There will be still ample time for lunch if we run that late, assuming that there are questions that take us that far. No format other than to raise your hand and address your question or your comment to whichever panelist, if there is a particular one you want to address it to, and if you want to make a general statement, not at great length, as a preamble to your question, that's fine too. So the floor is open. And are there questions? Yes, go ahead. The mics in front of you are on, so if you speak, you'll be heard. But that also means that if you tap the mics, you'll be heard as well. While you're warming up, I'll make a very quick announcement that I neglected to make earlier, and that is that on the 2nd of April, Herb Schwartz, who is a partner at Fish and Neve in New York, will be here at the noon hour to talk about the Federal Circuit, the first 20 years. Herb Schwartz is a legendary patent litigator at Fish and Neve, and this will be, for those of you who will be here, I think a real opportunity to hear a patent litigator talk about his experience and his observations of the Federal Circuit. That's the 2nd of April, 12:15 p.m., not in this room, but rather in the room upstairs, but we'll have announcements. Now, questions, comments for the panel? Yes.
I'm Jeffrey Graubart. I'm a copyright lawyer, but I'm here because I'm a Duke Law dad. Sitting here with my son Josh, didn't know I was going to be here for a copyright seminar when I came for this event, but I was delighted to hear what I was hearing, pleased as I could be to be here. But I have an academic question that I hope people on the panel can respond to, particularly you, Professor Lange. Transformative use was used several times by almost at least 2/3 of the panel. It's a concept, as I think Joe Beck mentioned, came from a footnote from Judge LaValle. That then Judge LaValle wrote about it, became a footnote in the two-life crew case. I had the honor to be arguing a case in 1991 before the Ninth Circuit, Tulo versus Los Angeles News Service. Because of being in that position, I read about Professor Patterson and what he had to say about the First Amendment. I was delighted to hear it repeated again now. But I want to go back to transformative use. As years passed after arguing that case, I said, didn't argue transformative use. It bothers me. Did I do something bad for my client? And went back and found that Judge LaValle's article was about the same year that the case was heard by the Ninth Circuit. But most recently in the Journal of the Copyright Society of the USA, someone, and I don't remember the name of the person, wrote a very interesting article about transformative use. And what I remember about it is, notwithstanding its use in a number of cases, she didn't seem to think there was really any need to have the doctrine of transformative use. I found it to be fascinating. I'd like to hear what the panel may say about it.
Sure. Joe, you mentioned it first. Do you want to respond?
Well, Jeffrey, is this on all right? Can you hear me? Yeah. I used to give my students at Emory Law School, where I teach intellectual property, an exam question to explain the difference between a derivative work and a transformative use. being law students, most of them regurgitated everything they knew about fair use. To my dismay, I had to read the exam. Correct answer was, I don't know, with hopefully an explanation as to why they don't know, because I don't know, and I don't know that there's a bright line. I'm somewhat persuaded by the notion that the concept of transformative use was already with us. The DC Comics case I mentioned, where Judge Shube, in effect, recognized that and then dismissed it in ruling for us. I don't know how long the doctrine is for our jurisprudence, despite the Supreme Court's use of it, because it's so hard to apply. Take a look at the Tie Inc. case that I mentioned in my PowerPoint. Judge Posner is rather derisive and characteristically of the Supreme Court's view. He quotes SunTrust prolifically. Judge Birch should get a royalty on that, but he's not.
Next time I'll see him, I can buy him a drink anyway.
But he is not at all pleased with the notion of transformative use, prefers what I think Ray Patterson would like, productive use. I don't have much else to add on it. I expect to be on both sides of the issue, hopefully profitably for the next 10 or 15 years.
Exactly.
Judge, do you want to say something about transformative use?
No.
No? I guess you can't afford to, Ray?
Yeah, transformative use is set forth by Judge LaValle is a product of ignorance on the part of Judge LaValle.
Do you wish to moderate that?
I should say a little knowledge. This is a case of a little knowledge being a dangerous thing. Because fair use began as an author's right, which really requires a new work produced. And in that sense, he's right. But the problem is, since Congress has subsumed personal use under fair use, if you say that fair use requires a transformative use, personal use is destroyed altogether. Because a person who makes a copy for research files, for example, does not transform. And I'm not sure that Judge LaValle recognized that point. But if you go back to 1841 in Folsom against Marsh, the fair use doctrine was created by Justice Story to supplant the abridgment doctrine. The abridgment doctrine was that anyone could abridge a copyrighted work and publish it without infringing the copyright. Justice Story said that's too much. So in order to substitute fair use for the abridgment, he said, in effect, a competing author can use a part of the work in creating his own work. But as I say, since Congress has subsumed personal use under fair use, the transformative doctrine does away altogether with personal use. And that's the problem.
Alec?
I guess I'll waylay that question a little bit and say what it says to me is, it's an example of how the fair use doctrine is actually expanding, not contracting. And people have concerns about fair use becoming more restricted, more contained. I think it's one example of many showing how the fair use doctrine is becoming more broadly applied and covering more things, and also that shows partly how technology allows a lot of new uses that then the courts have to figure out, well, with this new use that never existed before, are we going to take this doctrine and fit this new use into it? And that is creating a lot of the conflict that's out there today.
Dean?
Yeah, I'm a believer in transformative use, but not in the way that Professor Patterson sort of outlined. I think, when I think of fair use, I think that fair use is broad enough to encompass both categories of transformative use and certain types of personal use. I would say the use that's made, for example, in a classroom or news reporting use, well, maybe news reporting a little different, where you are actually making the copy of the work and not necessarily making any changes to the work, is not really a transformative use, but is still a fair use that's approved under the
Because it's
law.
in a
for
transformative setting?
Well, no, because of the purpose, frankly, of the use, of the purpose of news reporting, the purpose of criticism, the purpose of commentary. I think it's very important to see what is the purpose of the use. I believe in that. I can't remember, is it the first factor? No, second factor, third factor, I forget which factor it is. First factor, but I think the first factor is an important factor on fair use. And so when you look at personal use, is it purely consumptive? Is it purely market substitution, or is it not? And I think that's an important factor to consider as to whether or not it's a fair use. I like the transformative doctrine because, in my view, what it's saying is, in considering whether this use is a fair use or not, we're looking to see what independent effort, creativity the user put to the work to create something new. And so I think that's an important factor to consider. One of the cases when I was a law student that I was always very troubled by, and Joe, hopefully you'll know what the results are because I can never remember now, and I have to go back and look at it. There was a play called A Day in Hollywood, A Night in the Ukraine, where they took the Marx Brothers images, but I think all of the play was actually a new play. I don't think I think it was all original creation, but they used the Marx Brothers characters. And I was always sort of troubled. I can't remember whether it was the district court that found.
It was a district court, but Dean, if you remember, that was actually a right of publicity
It was a right of publicity case as opposed to a copyright case. But it even in the right of publicity area there, it troubled me because it was a new creative work. It wasn't sticking Groucho Marx on a box of cereal. Yeah. You know, it wasn't a pure, which I consider the pure right of publicity uses that the right of publicity is meant to go to, as opposed to these creative uses. So I have concern about, you know, looking at the creative component that's brought to bear. But I think Joe is absolutely right. Where do you draw that line between what's a transformative use and what's a derivative work? It's a very tricky line to draw.
You asked me about my opinion. I'm going to give it to you quickly. I'll tell you, this idea of transformative use did not originate with Judge Laval. It actually was introduced first in a book that was written and introduced just a few years after the 1976 Act was adopted, and I cannot remember the author of that work, but it was a work entitled Fair Use and Exemptions in Copyright Law.
Seltzer.
What was his name?
Seltzer.
Yeah, Leon Seltzer. Leon Seltzer wrote this little book called Fair Use and Exemptions in Copyright Law, and in that book he proposed that fair use could only be recognized in settings in which there had been some transformation of the work. Now, that question was argued to the Supreme Court in the Sony case, and the Sony case, the court in the Sony case, in a footnote, dismissed that argument as having no necessary validity, so that I had thought that had been put to death, but alas, it did not have a stake through its heart. And so later, when Judge Laval, who was then sitting on the district court, as I remember, had just decided, I think it was the Salinger case, wasn't it, that prompted him to write? Because he had ruled one way in the Salinger case, and then Judge Newman in the Second Circuit had reversed and announced this really weird doctrine for the Second Circuit. And the Salinger setting is a setting in which unpublished work is the subject of an appropriation. And the question is whether there's some special rule for fair use in that setting. And Judge Newman had said there was. Judge Laval wrote this article first, which he published in the Harvard Law Review simultaneously, or not simultaneously, but very shortly after his opinion in Salinger, relying to a considerable extent on a much longer, much denser work written by Professor Terry Fisher at the Harvard Law School, who had written a very, very long and discursive treatment of fair use. But what Laval added to this particular discussion was this idea of transformative use. Now, here's a problem, which is, I think, an increasing problem. When I was a tad, That isn't to say little, but young. It was not conventional for judges to speak in the way that judges now speak to issues of the kind that they may decide. Judge Birch has declined to do so, but that isn't true with every sitting judge. And for Judge LaValle to write what amounted to a dissenting opinion from the Second Circuit opinion reversing him, I thought was a real piece of chutzpah. But as with any sitting judge, and particularly a judge in the Southern District of New York, and then one elevated to the Second Circuit, what he proposes is likely to be something that is picked up by lawyers who litigate cases. So in a sense, the provenance of this idea is one of exigence and inadvertence. There isn't any long history for transformative use in any of the doctrinal development of copyright law. There just is none. Now, is it helpful? I'm of two minds about it, and I think I am sort of more on the dark side of what Alec sees as the upside. I see it as a potential limitation, but the Supreme Court has made it clear that transformative use, though it is perhaps helpful in some settings, doesn't necessarily limit the availability of fair use in other settings. And as long as that's the rule, then I don't mind having to confront the possibility, which is how Alec sees it, of being aided in arguing transformative use, as Joe did to Judge Birch in the context of the When Done Gone case. As long as we can keep transformative use in bounds in that way, then it seems to me that no great harm is done. The potential that I see and fear in it is that people will imagine that unless you have transformative use, as Leon Seltzer originally argued, that there can be no fair use, and that, I think, is not the law.
David, Leon Seltzer's book was part of the campaign of the copyright holders.
Well, I realize it was. I do realize it was. But on that particular argument, Leon Seltzer was unequivocal. You had to have transformative use. As to that, I think the Supreme Court simply set that argument aside in the Sony case. I don't think that can be, I don't think that was successful. I was concerned that Judge LaValle might, in effect, resurrect that idea, but I don't think he meant to necessarily. And the court has once again made it clear that transformative use can be used where it's helpful, but I think is not a sine qua non of a finding of fair use, exactly as Dean says. Dean, were you going to add?
Yeah, I just have I agree completely with what you've just said, and it leads me to a question, if I may, ask a question of Joe and of the judge, although I suspect the judge will decline to answer, but I'm going to ask anyway on the When Done Gone case, because it actually goes to this tricky boundary between transformative use and a fair use that's parody and creating a derivative work. And I have wondered, although this was not stated in either opinion, at the district court opinion or the 11th Circuit opinion, if part of what went into the decision is the fact that the Gone with the Wind was a classic, an icon, and an older work. If you had had the same sort of novel happen from, let's say, Harry Potter, which was a newer work, would necessarily the decision be the same, but the fact that this was an older work, that the author had had plenty of opportunity and time for economic exploitation, that it had sort of emerged as an icon, if you will, if that had something to do with the result of finding parody rather than an infringement of the right to create a derivative work.
I can see steam coming out of Judge Birch's ears as he struggles to not comment, but
No, I think I could comment on that. There's a current law review article out that you may be aware of. All those, I think it's pretty new because I think we get every couple of weeks our library sends us up the front sheet from law reviews, and we pick and choose what we like to have them send up to us to read in our spare time. And I happened to glance over this one article that puts forward a sort of sliding scale concept of, if it's been out, the longer it's been out, I don't like that. I don't think that was even, and I can state pretty unequivocally, that was not a concern to us. The fact that it had been around a long time and had been commercially exploited, and sequels and all that sort of thing. The thing that I think its icon status was certainly not dispositive, but relevant to the concept of what, to what extent it was a comment or criticism. The thing we grapple with the hardest, I suppose, intellectually, in the case was, and we commented on this, a somewhat confused state. I guess it was Justice Souter that wrote the concept that you talk about parity as making fun of, or you know, that sort of concept of parity versus criticism, comment, social statement, whatever you have. And we tried to reconcile that somewhat. We could have, as this law review article suggested, probably struck out on a new ground. Judges don't like to do that. At least judges I know don't like to do that too much. And so we tried to cabin, I suppose, our remarks, and I don't think artificially so, or to a point of contorting it, into the concept of parity. If anything, I tried to say I thought parity, the whole notion of parity, certainly embraced a lot more than just making fun of something.
Absolutely.
That it makes fun of it for a intellectually, hopefully intellectual advancement. That is, to comment, criticism, you know, sometimes laughing, being able to be self-effacing and laughing at oneself, and laughing at where we are. I think the passage of time, though, is interesting because it is an integral component of the very criticism that was lodged, and that is to say, I think, especially in the South, social awareness and social interaction and concepts of justice and what's right and what's wrong from the South in which Margaret Mitchell grew up and in which she wrote that book has changed dramatically to the present day. I think, frankly, notwithstanding your client, I didn't find the book all that terrific. I thought, and I've told many people, and I'll tell you that I think if they had not, I think it was a justifiably interesting commentary. I think the same commentary could have been a lot more artfully presented than that book was, but neither here nor there. If the Sun Trust people hadn't a Souter, it would have been in probably greater obscurity than it managed to be. So before you go read the book, it'll only take you about a day and a half. It's what my wife referred to after she read it, and she's a lot more critical about that sort of thing than I am, is a piece of puff presenting itself as intellectual. Anyway, I won't get into it. Then I might really get in trouble if I talk. But those are my thoughts on it. I don't think it had to do, although I think the time passage factor in the analysis of the criticism was important because things have changed, and I think she is pointing up the change, and that perspective she gives on all of that time and effort, as we and I think Judge Marcus, even in his concurring opinion, pointed out, was very important. Probably should be heard, and you know, I'm not saying it. I think her message was good. I'm not real crazy about the artfulness of her drafting the message, but it's interesting.
Yes.
First, I would just like to restate Professor Patterson's statement of copyright holders have shaped copyright law. And that I would like to ask that aren't laws like the DMAC barriers to entry for new independent creators and act as walls between consumers and creators set up by entrenched middlemen who desire to keep their hold on creativity and profits? In other words, I'm an independent content creator, and I would like to ask, isn't it hard, doesn't these laws make it harder for me to reach the level of audiences that I like to reach without the amount of funds that other large corporations have at their disposal?
Dean, go ahead.
No, Professor Patterson, please.
Go ahead now.
Okay. I would say actually no, because in fact, the DMCA, with its prohibitions on circumvention of technical protection measures, does not in any way impose a requirement on, for example, a breakthrough artist, a garage band, an independent movie maker to apply technical measures to their works in the first place. And in fact, when you know, a large copyright owner like a Warner's or Time Warner objects to the making available of our protected works on a peer-to-peer service. It's only with respect to our works, not saying that if a garage band, when this happens, decides to upload their sound recording onto a peer-to-peer service as a way of getting audience recognition and building a following and getting their work out there, that's absolutely permissible, and they are perfectly able to do that. And neither would we want to stop them as a corporation, nor do we have any right to do it. It's their original work of expression. If they want to make it available, if you want to make available whatever works you're creating on the internet, you can do so. We do not stand in the way at all. And in fact, that is supposed to be, and I think it is, one of the big boons and benefits of digital technology. It's because individual creators can reach a larger audience without having to go through a publisher. You don't have to go to a music company now to get your sound recording heard by millions of people. You can post it on the internet and it's there for the taking. And if a few people hear it and they think it's great and they start, emailing and going onto internet relay chat sites to promote it, boom, you can get the exposure without having to go through a company.
But the RIAA is not making it very easy for some of these technologies to exist. So by the destruction of some of these technologies, it's making it very hard for other individuals to continue using them because the ebb and flow and change of these distribution channels aren't always consistent.
That's a fair comment. I mean, I think when the RIAA, for example, sued Napster, one of the big arguments that Napster made in return was to say, there are some of the sound recordings here on Napster that are made available with the permission of the artist who has created the recording. The factual record showed that I believe it was over 98% of the recordings on Napster were in fact held by the major record companies who had not given the permission. So the fact that the overwhelming use of it was for piracy is what the court looked at. Did the court shut down Napster altogether, though? No, the court said, okay, Napster, you got to filter out the sound recordings that the copyright owners don't want on there and leave the ones that are permissible to be on there available to your service. Let's all be realistic here. That's not what the majority of users of Napster were going to Napster for, to find out what's the new grunge band in Seattle that's made their sound recording available. They were going after, Madonna and, okay, showing my age, the new James Taylor album, But I am in North Carolina, so hopefully I get a break for that,
I stand by my comment that copyright jurisprudence has been produced by copyright holders, not the creators. And ultimately, the purpose of the copyright holders is to have the power to charge monopoly prices. They don't want to trust their product to the market. And I think that Sony is the perfect example of this. If Sony had gone the other way, the power to charge monopoly prices would have continued. As it was, the movie studios produced video cassettes of motion pictures at a reasonable price, and people chose to buy the video cassettes rather than go to the trouble of taping the motion pictures off the air.
I really think it's about a leveling of the playing field, and there's a battle to prevent that leveling.
I'm going to move to another question. You had your hand up.
Yeah, I have a company that does IP protection. We've been talking to other entertainment companies, not AOL, Warner, about issues of, on the peer-to-peer side, interdiction and spoofing, which is the copyright owners actually uploading titles that have static or something so that the people trying to get free copies are actually getting static rather than the real thing. So they're not sure what they're after now. And then that would be spoofing. Interdiction would be the actually making or asking a company like mine to make multiple requests to actually delay the process or come up with the kind of network. So I wonder I don't think we're gonna do it just for business reasons, but are there IP issues for copyright owners doing those sorts of things, through a warfare patent?
It was an interesting, yeah, Alec?
My boss put in a bill last Congress that he said he probably won't reintroduce, at least in recognizable form this Congress, that would have created a safe harbor for copyright owners to use self-help technologies that don't cause any harm in the course of using those technologies. So his perspective is new technologies like peer-to-peer are great, exactly in the context Dean was talking, where a copyright owner wants to use them, but that it's the artist's choice whether their work's up there, not the pirate's choice, as I said earlier, and that if a copyright owner can come up with a technological method, interdiction, redirection, spoofing, that enables them to stop the piracy of their work, stop the illegal distribution, reproduction, without causing harm, that they should have every right to do so. And there are not necessarily copyright laws, but a variety of other laws, Computer Fraud and Abuse Act, spamming laws, false advertising laws, denial of service statutes that were written pretty broadly and could be read to prohibit a copyright owner from engaging in self-help that they would be able to do in any other context. So, his thinking was that exactly these kind of things are great if they're used in a responsible way, if they don't cause damage to the networks. Copyright owners should have every right in the world to go out and directly stop the piracy of their works.
They should have the right, or they do have the right?
Well, it's in looking at it, it seemed pretty obvious that under current statutes, things like spoofing, sending decoy files was okay, doing just the kind of bot searching was fine. But then when you got towards interdiction, just to use one example, one technology that's used is called first-in-line interdiction, where a copyright owner can look through a peer-to-peer network, see that Harry Potter is on a particular Kazaa user's computer, and then they go in and they request a download of that file. And if 5 ports on the computer are designated for Kazaa sharing, the copyright owner could request a download from all 5 of those ports and do the download at an extremely slow speed. Even if the person has a T1 and you have a T1, you can write the software, the introduction software, so that it takes 12 hours. Well, while you're downloading, no one else can go in and download. That helps stop the piracy. The problem is the Computer Fraud and Abuse Act is written to say that any access to another computer beyond authorization to obtain information is a criminal and civil violation. Well, the copyright owner is requesting information, the file, from another computer. They're doing it in a way that the person clearly didn't intend, a really slow download to stop other downloading. Does that violate the Computer Fraud and Abuse Act? Maybe. That's not what it was intended to outlaw, but it might. And these kind of broad legal prescriptions of against computer hacking may be prohibiting copyright owners from creating new technologies like interdiction that would be useful.
In the back, yeah. Yep.
Yes, my name is Swain Wood. I'm with Kilpatrick, Stockton in the Raleigh office. My claim to fame is that I carried Joe Beck's briefcase to the hearing in front of the 11th Circuit when the wind's gone. My career has gone steadily uphill from that. My question is, why is there, when these issues are discussed, such precious little discussion of what seems to me to be the central issue constitutionally, which is, are we, by having the laws that we have, promoting the progress of science and knowledge and the useful art? It seems to me that in Alec's discussion about the golden age of creativity, it sort of equates promoting the progress of science and knowledge with promoting the proliferation of entertainment. Why? I just wondered if everyone could give a sense of why there is such little discussion of whether the work that we're actually promoting by the laws that we have is good work.
Joe, do you want to respond to that?
Work that will last.
The U.S. State Department asked me to go to Russia in 2001 and again this past 2002 summer to talk about why United States intellectual property laws, and for that matter the rest of the world's laws, ought to be enforced. As Alec French mentioned earlier, there is a paucity of creativity going on in Russia right now. This is a country that gave us Tolstoy, that gave us Tchaikovsky, but not today. Russia today imports culture, exports talent, because a playwright in Russia is going to be knocked off even faster than Eminem, if he's any good. Now, I don't suggest that the United States is the most creative, prolific country in the world solely because we have copyright law. But Swain, I do think that that makes a difference. And while some would say that Eminem is not Tchaikovsky, and others would perhaps debate that, that's not the role, in my view, of, as Justice Holmes said in the Bleistein case, that's not what copyright law ought to be judging. That's for the market. We supply the market in part because a creative person in America can get extraordinarily well paid. And I'm for that. And my presentations in Russia, in St. Petersburg and Moscow, made that very point. And then we talk about Judge Birch's opinion in SunTrust to show that even if you bring a suit against, on behalf of Gone with the Wind, and bring it in Atlanta, Georgia, perhaps the most favorable venue in the world, to protect that property, you can still protect the public interest and protect copyright. So that's my answer to it. I think copyright does promote creativity.
Can I address that too, Professor?
Yes, sure.
I mean, you may not have heard it kind of as the topic here, but I think that that discussion does go on. I mean, again, having been there on the outside when the DMCA was for 5 years ad nauseum through dozens and dozens of hearings and 3 different committees and several different bills, when it was debated, that was the debate. The debate was, will this law, this new law, cause a dissemination of more works and more creativity, and in doing so, are we hurting at all any type of conduct that we want to promote? Fair use, scientific research. So the debate was, what do we need to do to get more works put out in digital formats and promote creation, and yet at the same time protect these types of uses that so many people have told us might be implicated? And that's why there are 9 exceptions, roughly, in the DMCA. That's why it went through such a laborious process, was specifically to try to strike that balance, make sure that it promotes creation and promotes things like use of the works, scientific use of the works, library use, educational use.
Judge?
The one thing that's always troubled me when you look at that argument, and the argument that's made all the time about creativity, and usually the folks, when they come to us and they argue, well, they focus on the author, the creator, the person who really has made the innovation, the original thought or expression, and sometimes both if it's a patent, original thought. That's very different, that person, it's usually a person, than the corporation who's exploiting it, the publishing industry or the industry that puts the patent to work or whatever. It's almost like if you're Madonna, you've got a lot of negotiating ability with the middleman, the publisher, the implementer, the exploiter. But if you are not of that stature at that point, either because of the merit of your work or its receptivity or whatever, then you're in a very different position. This is the unsaid, unacknowledged part of the debate or the concern, I think, that you'll hear mostly when you hear the industry side of things. That is not to say that people out there who want to aspire to a Madonna status, if they're a recording artist or somebody who's writing music or who's writing a book or a novel or something like that, all it is that ought to be factored into the whole equation. And I'm afraid sometimes that's not factored in to the point that when you talk about creativity, where does creativity come from? Not the publishers. They're going to strike the best monetary deal they possibly can with the new creator. And that creator may have to establish a track record to be able to, on a level playing field, and that's the industry. That's the free enterprise aspect of it. But it's a very real thing. So that there are other things that either stifle or create or promote creativity, and they're not all copyright matters.
Can I respond to that?
Yes.
If I may?
And this is going to be it, because by this time we'll be at 12:30.
So, sorry. No, I think what the judge has said is very true. Under the work made for hire doctrine, there is often a difference between who has done the actual creative mind work to create a work and who owns the copyright. But speaking on behalf of one of those dastardly middlemen, I would say, particularly for films, but for other works too, it's a huge, huge investment of financial resources that goes into creating some of these works. And the individual creators, frankly, whether it's Martin Scorsese, I can't even pronounce his name, but or any other director, can't put up the, $50, $80, $100 million that it costs to create that work. They need to look to a financial entity like a Warner Brothers to do that, and that cannot be overlooked either. As to, I think the publishers, the middlemen, the record companies, these companies, yes, they're money-making ventures, absolutely, but they invest a tremendous amount of resources into acts, and for every Madonna or for every Harry Potter, there's a musical act or a movie that's been heavily invested in that has lost a ton of money. And the individual creators still get paid their salaries. They don't have to pay back any of the losses. So it is sort of a balance. And one point that I'd like to leave with on that is, even in the civil law countries of Europe, where there's a much more stronger sense of copyright as a natural right, as a human right. In France, it's the droit d'auteur, the right of the author. For certain works like films, they actually, while they do not have a work made for hire doctrine, they have presumptions of transfer. In France, it's even an irrebuttable presumption of transfer, where those rights get transferred to the producing entity of the work. So it's part of the balance here, I believe.
Exactly.
Can we join in thanking a great panel for a great one? Lunch is available immediately outside.
Yeah. So